potential face-off between the Narendra Modi government and the higher judiciary is escalating. It's not just about appointment of judges, it's also about separation of powers. The Vice President of India, remember, yesterday suggested that the judiciary should not be reviewing laws passed by Parliament, essentially questioning the basic structure Keshwanand Bharti verdict of 1973 that bars the legislature from changing the basic structure of the constitution. The legal fraternity has now come out to slam Vice President Dhankar's controversial statements. But is the Modi government now spoiling for a fight with the judiciary? That's our top talking point.
The showdown between the executive and the judiciary worsens. The Vice President of India, in a fresh salvo at the Supreme Court, questioned the landmark 1973 judgment in the Keshwanand Bharti case. The 1973 verdict by the court bars Parliament from making amendments that change the basic structure of the Constitution. Dhankar said, in a democracy, the primacy and sovereignty of Parliament and legislature is inviolable. He then questioned the Supreme Court's decision to strike down the National Judicial Appointments Commission Act in 2015.
1973 में केशवानंद भारती के केस में सुप्रीम कोर्ट ने बेसिक स्ट्रक्चर का आइडिया किया कि पार्लियामेंट कॉन्स्टिट्यूशन अमेंड कर सकती है पर बेसिक स्ट्रक्चर को नहीं. विद ड्यू रेस्पेक्ट टू द जुडिशियरी, आई कैन नॉट सब्सक्राइब टू दिस. पार्लियामेंट ने कानून दिया, 16 असेंबलीज ने उसको रेटिफाई किया, महामहिम राष्ट्रपति ने अनुच्छेद 111 के तहत उस पर दस्तखत किए और उसके सामने एक सुप्रीम कोर्ट का निर्णय आ गया. कार्यपालिका के सामने दो मुद्दे, संसद द्वारा निर्मित कानून और सुप्रीम कोर्ट का निर्णय. सुप्रीम कोर्ट के निर्णय की तरफ कैसे झुक सकते हैं? हाउ कैन पार्लियामेंट sovereignty be compromised?
While Dhankar's views echo the Modi government's stand on the current system of appointment of judges in the Supreme Court and High Courts, his outburst against the basic structure doctrine is unprecedented.
There has been a concentrated series of statements against the judiciary. The judiciary now seems to be the new Nehru, a favorite whipping boy of politicians. The basic structure of the Constitution has to remain intact, irrespective of whether the current government of the day approves of it or not.
So for the Vice President to say that this is, not correct, I don't understand what is the basis for him to say. Probably he has forgotten that he used to be a lawyer at some point of time, and he has, after taking the oath as the Vice President, has completely, sort of wiped out his earlier career.
Meanwhile, the Supreme Court Collegium, in a recent letter to the Union Law Ministry, has reminded the centre about its obligations once again. While recommending an advocate's name for the third time to be appointed as a judge of the Karnataka High Court, the Collegium has said any name that has been reiterated by the Collegium has to be appointed by the government.
There seems to be no end visible on the horizon for this long-standing tussle between the Collegium and the centre over the issue of appointment of judges, where on one hand, the centre and high constitutional authorities, like the Vice President, have time and again spoken about the supremacy of the Parliament and how the judiciary cannot undermine the will of the people. The Supreme Court, on the other hand, through its judgments and its recent statements, has made it very clear that it is not the Parliament, rather the Constitution, that reigns supreme in India. The question is, will there be a new twist to this saga now, with the Vice President unveiling this fresh attack, questioning the landmark 1973 judgment of Keshwanand Bharti that had put in place the basic structure of the Constitution? With Kanu Sarda and Shrishti Ojha in New Delhi, this is Nalini Sharma for India Today.